Off a day, the Committee on Health, Land, Justice, and Culture is called to order. Today is April 6, 2022. The time's 10:01 a.m. In compliance with the open government law, notices for this virtual public hearing were published in the Guam Daily Post on Wednesday, March 30th, and again Monday, March 4th, 2022, and posted to the Government of Guam Public Notice portal. Notices were also disseminated via email to all senators and all main media broadcasting outlets on those same days. This hearing is being live streamed via the Guam Legislature's YouTube channel. The meeting is hosted by the Legislature's AV staff and my committee staff, and I thank them for their assistance with our Zoom platform. The host will mute all Zoom participants until called upon by the chair. Individuals testifying, I ask you to please identify yourself with your name and who you are representing before speaking so that we can keep that for record-keeping purposes. We have two agenda items this morning. One is Bill number 243-36 LS. It's relative to defining consent, revising the language of mentally defective to mentally impaired, and expanding the definition of mental incapacitation and physically helpless. The second item on the agenda today is Bill number 244-36 LS. It is relative to establishing a Bill of Rights for victims of sexual assault and to further citing this act as the Survivors' Bill of Rights Act of 2022. These bills will be more fully introduced and the titles fully read by the sponsor on her introduction of the bills. I'd like to acknowledge the presence of my colleagues here today. Beginning with my vice chair on the Committee on Justice, Senator Nelson, Senator Tello-Taitigui, Senator Joanne Brown, Senator Chris Duenas, Senator Jim Moylan, and Senator Mary Torres, who's the sponsor of primary sponsor of the two bills. So we begin with the first agenda item, and we're going to treat these separately. So we'll begin with Bill number 243-36 LS. If I could ask this primary sponsor, Senator Torres, to please introduce the bill.
Thank you, Madam Speaker. Bill number 243-36 LS was introduced by myself, Mary Camacho Torres, Therese M. Terlaje, Tina Rose Munya Barnes, Amanda L. Shelton, James C. Moylan, Jose Pedo Terlaje, V. Anthony Atta, Frank F. Blas Jr., Clynton E. Ridgell, Joe S. Agustin, Christopher M. Duenas, and Sabina F. Perez. It is an act to amend section 25.10A, 25.15A 4 through 7, section 25.20A 4 through 7, section 25.25A 3, and section 25.30A 2, all of chapter 25, Title 9, Guam Code Annotated, relative to defining consent, revising the language of mentally defective to mentally impaired, and expanding the definition of mental incapacitation and physically helpless. Madam Chair, Bill 243-36 LS represents months of research and collaboration with Guam's legal advocates and organizations. It all began in March of last year when the Minnesota Supreme Court issued a decision that overturned a felony rape conviction. The court ruled that a person can't be found guilty of sexually assaulting someone who is mentally incapacitated if the victim had voluntarily consumed alcohol beforehand. This, of course, immediately caught my attention because at the time, Minnesota's sexual assault laws were nearly identical to Guam's current statute. Just like Minnesota's, our law says that if you voluntarily consumed an intoxicating substance prior to being assaulted, you are not considered mentally incapacitated, regardless of a significant impairment in your ability to communicate. Rather, the mental incapacitation standard and the protections that came with it are reserved for only those that have been drugged or intoxicated against their will. This is commonly known as the Intoxication Loophole. Guam's physically helpless statute doesn't help much either. Under current law, only individuals that are asleep, unconscious, or physically unable to communicate unwillingness are considered helpless. While it is possible that individuals can be charged under these standards, our narrow definitions complicate prosecution when victims fall short of complete unconsciousness, which is too often the case. If enacted, Bill 243 would close this loophole, expanding the law to include any person under the influence of a substance that renders them incapable of consenting. It would also maintain the known standard, meaning that prosecution must prove that the defendant knew or had reason to know of the complainant's incapacitated state to be held culpable. Madam Chair, some may argue that this matter is best left within the confines of the court, subject to prosecutorial discretion. But the enduring issue of sexual assault here and across the nation compels our involvement. It is estimated that in the United States alone, 10 million women are raped while under the influence of alcohol or drugs. And our island of Guam is far from immune, with the second highest number of rapes per capita in the country. In making a case for the protection of voluntarily intoxicated individuals, the annual survey of American law states, and I quote, "Recognition of liberty does not mean that the government is foreclosed from criminalizing sexual activity where there is a legitimate state interest. There absolutely is such an interest in alcohol-facilitated sexual assault. Given the outsized role that alcohol plays in sexual assault, the state must step in with criminal sanctions," close quotes. Madam Chair, when a victim is so impaired that they cannot form the mental state necessary to consent, taking advantage of their vulnerability is nothing short of exploitative and should be punished by criminal law. The willingness to become temporarily impaired does not equate to consent, nor should an individual be less worthy of prosecution under the law by choosing to consume intoxicated substances. Moreover, in matters of ambiguity such as this, it's the legislature's role to make this prohibition clear. And the court says the same. In its decision to overturn the rape conviction, the Minnesota Supreme Court emphasized, in quotes, "If the legislature intended for the definition of mentally incapacitated to include voluntarily intoxicated persons, it is the legislature's prerogative to re-examine the statute and amend it accordingly," close quote. It has done so recently to address other perceived gaps in the criminal sexual conduct statutes. In short, instead of relying on judicially created law, the legislative branch should clearly codify these protections. That is why our statutes require change, Madam Chair, and that is why I authored this bill. Bill 243 has been extensively reviewed by some of our island's foremost legal minds, including former Office of the Attorney General Prosecutor Christine Tunoria and a team of criminal sexual conduct attorneys. A few months after our draft was written, my office received an email from the Bureau of Women's Affairs, who had been notified by Attorney Tunoria of the need to update Guam's laws. As a result, we provided her our draft, and following her thorough review, we added a definition of consent for the first time to the Guam Code Annotated, using the new language that Minnesota has since adopted and enacted. Further, upon the recommendation of the General Counsel of the Office of the Attorney General, we revised the outdated term of mentally defective to mentally impaired. And should this bill become law, Guam will join a growing list of states that recognize the need to protect the voluntarily intoxicated. But perhaps more importantly, we will send this clear message to our community that alcohol use is never an invitation to rape, and those who prey on the severely intoxicated will be punished. And if our victims have the strength to come forward, the law will be there to support them. And that is the intention of Bill 243-36 LS. Thank you, Madam Speaker.
Thank you, Senator Torres. So before we hear from the witnesses who are here to testify, for the record, the committee requested feedback in addition to the public notices, specifically from the Bureau of Women's Affairs, Guam Behavioral Health and Wellness Center, Office of the Attorney General, Guam Public Defender Service Corporation, the UOG Violence Against Women Prevention Program, the UOG ISA Psychological Services Center, Catholic Social Services Ali Shelter, UOG Social Work Student Alliance, and Vero Family Rights. All right, we'll now hear testimony beginning with the Director of the Bureau of Women's Affairs, Ms. Flores.
Thank you, Madam Speaker and honorable committee members. Sijus Masi for the opportunity to testify in favor of Bill 24336 relative to defining consent, revising the language of mentally defective to mentally impaired, and expanding the definition of mental incapacitation and physically helpless. Again, my name is Jane Flores. I'm the Director of Bureau of Women's Affairs, and I also serve as the Administrator for the Governor's Community Outreach Federal Programs Office, which handles all of Guam's Office of Violence Against Women grants. First, I would like to thank former Assistant Attorney General Christine Tunoria for bringing to my attention this loophole in the Guam law that this bill will close when it passes. Ms. Tunoria first brought this issue up during a sexual assault response team or SART review committee meeting back in May of 2021, I believe. She recalled the case in Minnesota as the bill's legislative intent section, and yourself, Madam Speaker, just noted, wherein, or as sponsor Senator Mary Torres noted, wherein the Minnesota Supreme Court overturned that rape conviction because the victim had been voluntarily intoxicated, and that voluntary intoxication did not meet the state's definition of mental incapacitation. Ms. Tenorio noted that Guam's law was similarly written. She said she had been admonished by a judge, and I hope, Christine, that I'm getting this right, by a judge during a sexual assault case for claiming that because a victim had been voluntarily intoxicated that she could not consent to sexual activity. And in that case, I believe the judge noted that Guam law did not allow for that claim, as has been mentioned. Ms. Tenorio stressed the importance of closing this loophole in our laws. Senators, the trainings that the Governor's Community Outreach Federal Programs Office funds through our Office of Violence Against Women federal grants all teach that if a person is intoxicated or drugged or otherwise mentally challenged, even of their own volition, that person cannot consent to sexual activity. The Guam Coalition Against Sexual Assault and Family Violence recognizes and teaches the community this as well. If someone gets drunk or drugged, no matter how they got drunk, that is not license for someone else to sexually assault them. Except that, according to current Guam law, it is. This sort of attitude is what the coalition and all of us who are working to reduce and one day hopefully eliminate sexual assault fight against on a daily basis. It is known as victim blaming. You blame the victim for getting drunk. Therefore, the sexual assault that ensues is her or his or their fault because they were drunk or high or whatever. We need to fix this now. I want to thank Senator Mary Torres and the 11 other senators who are listed as sponsors of Bill 24336 for addressing this issue and working to close this loophole in Guam law that basically allows for victim blaming. The sooner the law is updated to include any form of mental incapacitation, whether voluntary or involuntary, as the inability to consent to sexual activity, the sooner we can chip away at the high rate of sexual assault that has spread like a cancer through our community. Sijus Masi for this bill and in advance for what I certainly hope will be its unanimous passage in the 36th Guam Legislature. Sincerely, thank you.
Sijus Masi, Ms. Flores. Attorney Tenorio.
Thank you, Madam Speaker, and good morning to Senators of the Guam Legislature. My name is Christine Tenorio. I'm a former Assistant Attorney General with the Prosecution Division. I was the head of the Sex Crimes Unit for 4.5 years, and I was a prosecutor for 9 years. So this set of crimes, I did sit on the sexual assault response team with Ms. Flores. We did a lot of work together, trying to figure out how we can better help our victims and how we can navigate through the legal system to help them better. Now, I do want to start with an overview of where Guam law currently stands, just for everyone's awareness. There are two ways, among many, but there are two different ways to commit criminal sexual conduct. One is by force or coercion, but the way Guam law is written right now, under the case as interpreted in People v. Tunoria, which is a 2007 Guam Supreme Court case, is you have to say no or indicate lack of consent in order for the case to even be charged. It's not really a prosecutorial discretion issue. It's a bar to prosecution. So if we have a case where a victim didn't say no or indicate some time of lack of consent because they were immobilized momentarily or they were under the influence of alcohol or drugs, we cannot charge it under that subsection. That's where we go. That's what brings us to the subsection that is the point of, or the subject of the public hearing today, is mentally defective, mentally incapacitated, or physically helpless. Now, prior to the Supreme Court of Minnesota's opinion in State v. Khalil, the prosecutors were proceeding under that subsection to prosecute a victim or defendant who took advantage of victims who were clearly intoxicated and could not consent under the law. Now, our difficulty as prosecutors was that consent was not defined, so we weren't able to say or prove whether someone consented or not because they were too intoxicated to do so. So the way we were going about it was we were just saying, well, clearly there's evidence of intoxicated. We were inferring from the law how we could proceed. Well, when the Supreme Court of Minnesota struck or overturned that conviction, it really, really changed the landscape of prosecution because we had to view all incoming police reports with a different lens, which is if the person was voluntarily intoxicated, consumed alcohol or drugs at some point in the night, and later on was a victim of a sexual assault, if they were too drunk and they couldn't say no, we actually could just not charge the case. And so when I was at the AG's office, so many cases went uncharged because of this loophole in the law. And Ms. Flores is correct in that this came up during one of the trials, which is fine because we had other legal theories to cover the conduct, but it was a defense attorney argument that we couldn't proceed under this. And so that was correct. So the reason why that this bill is very important, and I thank the sponsors of this bill for introducing this, is we, like Ms. Flores said, the way the public perception is, and I know this from speaking through all of the different panels of jurors we get from jury selection, is everyone wants to know whether that the victim was intoxicated at some point. It becomes a victim blame game as far as she should have known better because she should have known not, or he should have not known not to take X many drinks or consume X many drinks in one night. So what this does though is that it closes that loophole, and as long as the prosecutors get the opportunity to argue to a jury that this person was too intoxicated to be able to consent, then those victims can still be treated as such, as victims in the criminal justice system, because currently they are not. I do have to say, so I had gone to National District Attorneys Association conference for sex crimes for 4 years, and most of other jurisdictions have this definition of consent. And actually Minnesota, which is where our 90 CA 25.10 comes from, Minnesota law also has that definition of consent, which is why the consent definition is provided in the current amendment. So what it's going to do is basically bring our statute up to date with the current Minnesota law. Since that Minnesota Supreme Court struck down that law, the Minnesota legislature did pass the bill with the current language that's proposed. That way, that was their way of closing the loophole. And so because Guam's 25.10 is Minnesota law, then I think is only, it's necessary for us to amend the law so that we can comport with our state counterpart. I do want to highlight that I've heard some arguments against this law saying, well, this just makes it easier for anybody to report a rape, if they're too drunk. These victims are to come forward and say, oh, well, I was drunk, so I didn't consent. And so I do want to dispel any notions where I think people would say this gives people more of a way to fabricate stories, I think was the notion that I got from different conversations I've had with people. And what I do want to highlight is it doesn't change the defendant's intent, because the example being given all the time was, well, what if the defendant was too drunk? You're going to charge him and then that's it. It's always the male's fault. This is not that. To prove criminal sexual conduct, we actually have to prove intent. You have to intentionally engage in the conduct. So these are meant for perpetrators who are intending to take advantage of someone that they know or have reason to know is too intoxicated to consent, whether it's intoxication by drugs or alcohol. So this is going to close a very sad, it's a very sad loophole that we have, because so many, women that I've worked with, they didn't understand why the law is this way. So I just want to thank the sponsors of this bill, and I hope that everyone has a better overview now of how this is going to affect the prosecutors going forward, and how this is going to make sure that no victim gets left behind on account of their choices. Thank you.
Thank you very much, Attorney Tunoria. We have the Deputy Attorney General, Fred Nishihira.
Thank you, Madam Speaker, members of the committee. My name is Fred Nishihira, Deputy AG for the Consumer Protection Division, but the Victim Service Center also falls under that division as well. I want to start by disclosing that our testimony today will be limited because we have some ongoing criminal cases that may impact. So I do want to testify that we are in full support of this bill, which will codify that consent should be affirmatively given and cannot be given when someone is physically helpless or unable to communicate consent or non-consent because they are under the influence of alcohol or any other substance. And although our criminal sexual conduct statutes are not identical to Minnesota's, the proposed changes to Title IX, Chapter 25 will remove any doubts that it is a crime to engage in sexual act with someone under these influences. Thank you very much, Madam Speaker.
Thank you very much, Deputy AG Nishihira. We have Kimiela Babalta, UOG Social Work Student Alliance. Ms. Babalta.
Thank you, Madam Speaker. Buenas and Hafide Honorable Senators. My name is Kimiela Babalta. I am an undergraduate student in the Bachelor of Social Work program and testifying on behalf of the Social Work Student Alliance at the University of Guam. Thank you for the opportunity to provide testimony in favor of Bill number 243-36 to amend current language involved with consent and sexual assault. The proposal to amend the terminology involved with sexual assault is necessary in assisting victims and providing them justice. Defining consent, clarifying the term mentally impaired, and expanding mental incapacitation plays a vital role in determining social justice for sexual assault victims and deterring perpetrators from committing such an act. In May of 2017, a female in Minnesota who had consumed 5 shots of vodka and prescription drugs willingly before going out clubbing with her friend was invited to a party at a house. They agreed, but when they arrived, there was no party. The female passed out on a couch and then woke up to a man sexually assaulting her. The man was charged for third-degree criminal sexual conduct. However, 4 years later, the Minnesota Supreme Court overturned the ruling due to the female being voluntarily intoxicated, which did not meet the state's definition of being mentally incapacitated. This case brought international attention to issues with existing consent laws. Minnesota Legislature updated its criminal sexual conduct laws last year. Many of us have consumed alcohol either at a social gathering or for leisure. But how many of us ever thought that if we were sexually assaulted, our perpetrator could be set free because we opted to drink? The Rape, Abuse, and Incest National Network reports that for every 1,000 sexual assaults, 975 perpetrators will walk free. It is essential that we stop blaming victims and instead strengthen policy to treat all sexual assault cases as a crime. In 2021, the Guam Coalition Against Sexual Assault and Family Violence reported that there were 190 reported cases of sexual assault in 2020 alone. Alcohol and intoxication can be common denominators when rape occurs. However, just because an individual is voluntarily intoxicated, it does not give another individual the right to commit sexual assault. Expanding definitions in Bill number 243-36 will protect victims incapable of providing consent. Through this expansion, they will be classified under the category of mental incapacitation. Individuals who become victims of sexual assault, even if voluntarily intoxicated, should not be blamed or have it held against them. The person responsible for sexual violence is the person who commits the act of violence. As a member of SWASA and a future social worker, I urge all members of ILHIS Laturan Guahan to support Bill number 243-36 to provide a voice and to raise awareness for individuals who are incapable of providing consent and who would fall under the category of mental incapacitation. Thank you.
This is Masi, Ms. Babauta, and the Social Work Student Alliance for your testimony today. We'll now hear from Frankie Ann Beneventi, UOG Social Work Student Alliance.
Greetings to all honorable senators. My name is Frankie Ann P. Beneventi. I am a student at the University of Guam in the BSW program at the School of Health, representing the Social Work Student Alliance as a Sergeant at Arms. I am writing in dedicated support of Bill number 243-36 to amend defining consent, revising the language of mentally defective to mentally impaired, and expanding the definition of mental incapacitation and physically helpless. The Guam Police Department's Crime in Guam 2019 Uniform Crime Report indicates that reports of rape have decreased from 160 in 2015 to 116 in 2019. In that same time span, rapes that were cleared by arrest also decreased, with 51.2% cleared by arrest in 2015 and 32.8% cleared by arrest in 2019. This data shows that the rape volume is higher than those cleared by arrest. In April 2021, the Guam Daily Post reported statistics provided by the Guam Coalition Against Sexual Assault and Family Violence. For the year 2020, 190 cases of sexual assaults were reported, but an estimate 63% of sexual assaults were not reported to the police. It is alarming that more than half of sexual assaults are not reported to the police. We hope that revising the language of the law, as this bill proposes, will encourage victims and the public to report incidences of sexual assault. The University of Guam Violence Against Women Prevention Program cited the FBI Uniform Crime Report that Guam has the second highest number of rapes per capita in the United States. There are 64.2 reported rapes per 100,000 people in Guam, compared to the national rate of 25.2 per 100,000 people. And dedicated support of Bill number 243-36, we urge you to consider these startling statistics. We hope that amending and revising the language in relation to sexual assault will encourage victims to come forth and report cases to the police and increase criminal liability for sexual assault in circumstances when a victim is impaired, physically helpless, or intoxicated, whether voluntarily or involuntarily. It is imperative that the safety of our people is our top priority and that we strengthen policy to deter, prevent, and prosecute sexual assault. I urge all members of the 36th Legislature to support Bill number 243-36. Thank you for your time.
Thank you very much, Ms. Benavente. Really appreciate your testimony today, and the Social Work Student Alliance is interested in this bill. We'll now hear from Stephanie Lorenzo, the Speaker of the Guam Youth Congress. Speaker Lorenzo.
Sizos Maasi Speaker Terlaje. Buenas and Hafide. My name is Stephanie Lorenzo, and I'm here in my capacity as Speaker of the 33rd Guam Youth Congress to testify in full support of Bill number 243-36 LS. So this bill aims to clarify existing issues in the law where intoxication falls short of complete unconsciousness and victims who voluntarily consume intoxicating substances are not considered mentally incapacitated, regardless of the inability to understand the sexual acts that follow. This is critical as Guam law currently does not protect an individual who voluntarily consumes the intoxicating substance, and a sexual assault does occur when a victim intoxication impairs cognitive or physical functions that, to the extent that it prevents their ability to consent. Speaker Terlaje, we also sent in addition testimony as well, so I'll just end it there and everything else is in your email. Thank you, ma'am.
Thank you very much. We are in receipt of that written testimony and appreciate that from the Guam Youth Congress. All right, so is there anyone else who I've missed who was here to testify on this bill? If not, then we will proceed with the questions from the senators, beginning with the sponsor of the bill, Senator Torres.
I don't have any questions, but I just want to thank everyone for providing testimony. Jane Flores and Christine and Fred, you've been invaluable in your contributions and your assistance in formulating this piece of legislation, and we owe you a big, we owe you a lot of gratitude for your consistent facilitation and assistance in this legislation. And I'm very pleased that Camilla and Frankie Ann and Stephanie have also provided testimony. One of the things that is the comments that was made is that I think we all can appreciate is that we have the second highest statistics for rapes per capita in the nation on Guam, which is just startling. And then we also, of that, more than half of all sexual assault cases don't even go reported. So I think everybody understands and appreciates that with laws right now that deal with the extreme cases of what is incapacitation or that we have to not deal with the extremes, but we actually have to deal with everything else. With statistics as large as they are, the people that are not being that are affected, that are not reporting or have no sense of justice in reaching out for help or prosecution, I think have a glimmer of hope, a tremendous amount of hope, I would say, with this type of legislation. So thank you everyone for recognizing that and for putting so much effort into not only formulating this piece of legislation along with my office and our co-sponsors, but also in supporting it as well. Thank you, Madam Speaker.
Thank you, Senator Torres. Yes, I'm also, of course, as a co-sponsor in support of this bill, and I'm very much glad to hear the AG's testimony that if this bill would require that consent be affirmatively given, and that instead of what seems to, from this, Attorney Tenorio's testimony, have been previously required, and that is that the Attorney General's had to prove that someone said no, as opposed to that they said yes, right? That the defense would have to prove that they said yes. And so I think I am very hopeful this is going to change the ability of the prosecutor's office to prosecute these cases and to get convictions. I have a couple questions. One is there some procedure that's going to be done or that you would recommend that where they prove that the victim was under the consent, under the incapacitated by alcohol? Like, would you suggest to the where they do the rape tests up at when they're doing that they're also going to do alcohol blood level tests or anything like that? Do they do that in any jurisdictions? I wasn't able to check. Or are we just taking their word for it that they were intoxicated?
Madam Speaker, I can answer that question.
Yes, please.
Okay, so that one we take on a factual basis, and that's what prosecutors are assessing when they look through police reports, is any facts that lend to that. So there would be no requirement to ask for somebody's blood alcohol content level. To some extent, at Healing Hearts Rape Crisis Center, they do go into the history, and by history I mean the history of what happened previous or prior to and afterward. And so there are questions that pertain to whether they had consumed alcohol. Surprisingly, not everybody who reports to the police actually ends up going to the Rape Crisis Center. So a lot of times we don't have that information, but under Guam law, victim testimony need not be corroborated, which means it's not a bar to going forward. So what we would do, and that's where the investigation comes in, is we interview witnesses surrounding the event so that we have other testimony from other witnesses that do corroborate that.
Okay, and I noticed that so our language in this bill says that corroboration is not required.
Right.
So you can go ahead without that as well.
Right.
And what about, so you've mentioned it, Attorney Tunoria, regarding whether this bill affects the incapacitation of the offender or the defendant. Can this bill be used by defendants to say they were the one that was drunk, so of course they did not have intent to commit the crime? Or is this strictly a bill that applies to the victims?
So the defendants wouldn't be able to use it as a sword, but that would be their line of defense. Well, not always, but it is a lot of the time a line of defense that they use at trial anyway. So this bill will not bar them from using that. They can say the defense is normally, well, I also was too incapacitated to have intended to commit this sexual assault. So that defense will still be available to the defendants. They just can't use this as a sword for that.
So that's available to them by another statute, not by this one necessarily.
Correct. That's available to them. Well, actually, the statute actually says voluntary intoxication is not a defense to the crime. So, I mean, while it does say that, they are able to try to use that defense if the facts permit at trial. So that's still available to them by a different statute, correct?
All right, thanks. And does a victim need to be unconscious for this under the influence, or that renders them incapable of consenting? Would they need to be unconscious? I just want to clarify that. Or can they be functioning, but yet under the influence, incapable of consenting?
They would not need to be unconscious under the current subsection that we are trying to add. That is covered by the subsection that precedes. There's different ways that you can be mentally incapacitated, and that would go under a different subsection, whether the victim is unconscious. I do want to say that the definition that is currently on the books is that it's physically helpless, the physically helpless portion is, or for any other reason is unable to act. So the problem with that section is that it doesn't cover the voluntary intoxicated people. So that's really the loophole. So we're just trying to make it very clear as far as what the victim, be it not what's required of a victim, really. Honestly, the way the criminal sexual conduct statutes are currently worded is you as the victim are required to prove all these things, even though that's not what it's really the defendant, that conduct that is at issue. But when the victim takes the stand, they have to really go through all of these requirements and testify, what they remember, what they don't remember. And it's just really a hurdle for prosecution. So this will shore that up. But no, they do not need to be unconscious under the current proposed additional language.
Okay, great. And under the proposed language of subsection B, mentally incapacitated means under the influence of a substance that renders them incapable of consenting. Do we need to specifically say, I think you said that this language was copied from Minnesota, what they've adopted now, but do we need to say the word voluntarily in there, or we're good without it?
That can be it's a good addition if we want to be very specific, and just so that nobody has the argument that nobody, tries to argue, oh, well, it's also involuntary intoxication. I do think that it can be inferred by subsection A. Normally, the way the Supreme Court interprets law is if it is in subsection A, if the legislature specifically put administer to that person without his or her consent, and that language is not repeated in B, then they'll actually rule that because the legislature was silent on subsection B, then that doesn't apply. But I do think that would be a good suggestion if to make it clearer.
We'll see. Let me know. Again, all of you, please submit in writing if there's any additional recommendations that you have after this hearing. We'll allow the other senators now. Senator Nelson.
Thank you, Madam Speaker. Thank you, everyone, for giving testimony today, and thank you, Attorney Tunoria, for bringing this situation into the light. I did share the same concern that the speaker had in regards to if the perpetrator was also intoxicated, but thank you for clarifying that issue. I believe this bill is a strong bill. It's a good bill that helps our community. It reinforces that sexual predators need to be aware of their actions, and that there's a consequence these days for these types of actions, especially when that individuals are taken advantage of who are intoxicated or are utilizing other substances. That this type of behavior, preying on individuals who are vulnerable, will not be tolerated within this community. I believe that as we move forward with this bill, we need to educate our community, alert them of the consequences of these type of actions, so that also victims understand their rights, and they understand that they can be more vigilant in this process. So thank you, Madam Speaker, and thank you everyone for giving testimony.
Thank you, Senator Nelson. Senator Teichfried.
Thank you, Madam Speaker. It's very helpful, being an attorney yourself, to cover some certain areas that we don't know much about. But I appreciate the comments that you made as well. The one thing I wanted to ask, though, Attorney Tunoria, thank you so much for being here, by the way, as well as Fred Nishihira and those who came and testified on behalf of this legislation and providing your stories and your concerns. The one thing that was mentioned earlier with regards to, it was said if the defendant was also intoxicated, but if you come into a scenario where both individuals were both very much intoxicated, and next thing you know, it's almost like who's going to be first to file a complaint, to be the plaintiff versus the defendant. If they're both very intoxicated. They wake up and say, wait a minute, you raped me. And then he says, no, you raped me. And then next thing you know, they both go try and file a case. Could that be a situation? And how would that be addressed if they're both claiming rape on each side?
So in my whole career, I've never had that issue. I just wanted to give historical background, right? We've never had an issue where one says, no, I was the one, or, he raped me, no, she raped me. We've never had that situation. But to the extent that you are concerned or others are concerned that this would create that situation, that's where the prosecutorial discretion comes from, right? You actually have to know what you have to prove intent at trial. So it's whoever had the intent. And that's why I keep going back to that. It's the person who had the intent to take advantage of the other person is going to be the one that's charged. But if you don't have that intent, if you don't have that intent, then it's not criminal if you don't have the intent to do it. So I don't know if that allays the concern. That's really what happens when historically, right? So a lot of times, normally people call this the he said, she said, and criminal sexual conduct is usually he said, she said cases. That's actually why nationally drug and alcohol facilitated rapes are very hard to prove. They're the hardest to prove because one of the parties is always like, well, I didn't know that she didn't want to do it. This bill closes that gap. Maybe you didn't specifically know, but did you have reason to know? So if that specific language would be able to help the prosecutors figure out who did have the intent. Because if we can't prove an element, if we don't have probable cause for intent, we can't charge it.
I see. So it goes beyond. So, okay, then that's more investigative, before the whole incident, that's going to play a huge role. So whether he's a stalker or she's a stalker or, any kind of situation, then that would try to bring a lot of insight as to who's really the plaintiff here or the defendant. Okay. But, with legislation like this, it opens the doors, for the other side to provide some kind of defense, on their part, on both sides, male or female, in situations. And I have heard in the past that males have actually, filed a rape against an individual because they were intoxicated at the time. And the female took advantage of him. So it's not something that's not happened or unusual. My concern too is the verbiage of using a voluntary intoxicated. I didn't know, I noticed in the legislation, I didn't see that. I only saw consent means words or overt action by a person indicating freely given presented agreement. But in the legislation, I think the speaker actually brought this up with regards to using the verbiage voluntarily intoxicated. Should it be anywhere in this legislation just to, provide that the loophole or any kind of hole in this legislation that does not address it? Do you think, Attorney Tunoria, it should be indicated in here?
I think that the speaker's suggestion was a good one, and that where it would be indicated would be the subsection B. That a person, you could put that a person is voluntarily under the influence of any substance or substances.
Voluntary intoxicated, or wouldn't you use intoxicated? Because we're talking about under the influence. Right. So in the legal definitions, influence of any substance or substances would cover intoxication. Okay. So that is the definition. So it wouldn't be an issue there. And you mentioned, Attorney Tunoria, in section what? Section B? Subsection B. So that's the proposed language under section 6, subsection B, the proposed additional language. Okay, there I see it. Okay. Well, thank you so much. And thank you for advocating for something like this. And I'm sure we all stand in support of anything that's going to help our community address, situations where it should be prosecuted when someone is in a situation like this, and people, just one drink could put them in a state of intoxication, and some people may realize and take advantage of individuals, and that's what's happening here. It's those people taking advantage of victims that are not in their mental frame of mind. So thank you to Jane Flores, the director, for also advocating for this particular legislation as well. Thank you so much, Madam Speaker.
Thank you, Senator Thackray. Senator Duenas, you're recognized.
Madam Chair, and once again, I'd like to thank all of the participants, particularly Attorney Tunoria. Thank you for your expertise and your advocacy over the years. It's really important, particularly on this type of legislation where you're amending the law to really become more definitive. And so for non-law people, laymen, it's really good to understand. And I'm sure that going forward in further trainings, this will now be standard in training it, and the work that the organizations such as the university students represent today will have the opportunity to further educate the public. So I just thank you for that expertise, because it's very important in public hearings to get that as we're deciding on legislation like this. I'd like to thank Senator Torres for inviting me to be a co-sponsor on this bill. I think it's super important legislation. And once again, just thank you all for what you do every day. And thank you, Fred Nishihira, also. I know it was a confined, testimony, as you said, because of the fact that you're actively engaged in prosecution, and we understand that. But the full support from the Attorney General's office and your representation, I think, is extremely important here. So with that, Madam Speaker, Sujus Masi, to share some of my thoughts.
Sujus Masi, Senator Duenas. Senator Brown.
Thank you very much, Madam Speaker. I don't have any questions. I don't know, of course, our hope is that if anyone violates the law and does something wrong, certainly harms another individual, that there's consequences to that. I don't know when people commit these acts, whether or not they're concerned whatsoever with what those consequences are, but we certainly have an expectation in society that there's justice. There's the hope. That's not always the case. Don't need to be an attorney to figure that out. I hope it would deter, but I'm sure in dealing with some of these cases, which are frequent, every single day in the paper, we continue to hear about sexual assault happening in our community, especially to our children. And it's very, very, very disturbing that continues. And I don't see it slowing down. I don't see it being abated. We're in the political season and everyone wants to take credit when things are crimes going down, but what we're seeing is that crime's going up, and especially the direct crime. Not, it's one thing of stealing, property. That's not acceptable, but gosh, the physical harm that's happening in our community, the victims that are out there, particularly those that cannot protect themselves, particularly our children, even though I know the focus of this particular bill has to deal more so with probably someone who's consumed alcohol and not wanting that to be a reason why they can't defend themselves from being, victimized. But that's a concern and that growing problem. I don't know what it is in our human psyche that allows this type of abuse to happen. We're trying to catch up in our court system to prosecute these cases, but it's just so offensive to continue to see the victimization. Of course, it's not always women and children. It's also men in our community, but a much smaller percentage. But it's just very disturbing that we continue to see the increase of these type of violations. And certainly from my point, I have no reservation in strengthening the laws to make the consequences harder or more difficult, extending time of punishment if necessary, or increasing the amount of time served if necessary for individuals that violate the rights of others, particularly with regards to sexual assault. How personal can that be? And certainly any step we can take, but it's trying to understand why this continues and why it's so prevalent in our community, that we have so much sexual abuse happening and sexual assault here on island when, we're raised to respect each other. And especially, gosh, it's so disturbing. I see so much of children every single day in our community that are being violated. Our children that we we know are our most vulnerable. We think of our own kids, our grandchildren, others in our family that we couldn't even imagine these things happening to, and the amount of emotional and physical harm that comes to our community, especially these children, because we as adults are not doing what we need to do. And I don't know what it is ultimately. I mean, I'm throw away the key attitude with stuff like this because I'm so disturbed and disgusted by it. So I certainly will support this bill. Like I said, I know it's primarily probably to address the issues of, an individual, if the victim has consumed alcohol, to now not use as an excuse not to recognize that that individual's been victimized. So I certainly support it. But, the underlying issue that's happening on Guam and is the sexual abuse and the sexual assault in our community. I don't know how we're emerging as a better society when we seem to continue to have these problems, and the fact that it's growing, at least of the cases that are even reported. Those are cases reported. What about the cases we never, because of shame and other things in our community, never get reported? We never know that these things are happening, or only because, fortunately, sometimes in our schools, it's our teachers and counselors that are the ones that identify that especially our children are being harmed. I mean, I know I'm going on, but I just am so disgusted to continue to see this in our community. And I think we just need to bring better awareness and keep talking about it. And I hope that people that are intending to victimize others, I mean, I don't know if they think about the consequences when they do what they do, but so be it. If they do it, then by all means, there needs to be tremendous consequence for those actions. So with that, Madam Speaker, thank you for the opportunity to comment with regards to this bill.
Thank you very much, Senator Brown. Senator Moylan.
Thank you, Madam Speaker. Thank you to the author of the bill. I appreciate the panel's comments, Attorney General for their support, UOG students, thank you for your comments, and Women's Affairs, of course, especially Attorney Tunoria. That was very clear and concise in how we need to move this bill forward. So thank you, panel. Thank you, Madam Speaker.
Thank you, Senator Moylan. Senator Perez, you're recognized.
Madam Speaker, this legislation is really important, and I thank the good sponsor for this piece of legislation in closing an important loophole. And also thank you to Attorney Tunoria and all the Attorney Nishihira, as well as all that have come here in support of this bill. I think there definitely was a big loophole in our law currently, and I think consent is what's needed for sure. And I do see that in addition to what's been stated earlier regarding those that are under the influence, what I also like about this bill is that consent does not mean the existence of a prior or current social relationship between the actor and the victim. And I think that's really important to also highlight, because just because you're in a relationship, people assume that, rape doesn't occur. And, we need to highlight that too as well. And, I really am in support of this legislation. Anything we can do to strengthen our laws, because we are currently in an epidemic, in regards to rape, sexual abuse. We need our laws to match the needs of our community. And I think this is one very important measure that can do this, in addition to other measures that are needed. Like the retiring speaker said, awareness. What happened to the training within our community? What's happening within our community? This is such an epidemic. And anything that we can do to support, prevention. How can we prevent this from happening? So in addition to enforcement actions, we also have to have this multi-pronged approach as well. And I know we have another bill coming up, which will hopefully address this. So Tzedu's Masi.
Senator Perez, before I hand it over to the sponsor, I'd just like to reiterate my thanks to everyone for testifying. And I'm hoping that the student groups that are here today and victims advocates groups and agencies are going to be able to use this when it is passed to help us to bring victims forward, to bring victims to prosecute the offenders, because we know that they're very hesitant and for good reason. I mean, it's a very difficult thing to go through. We're hoping that this bill will also be used by prosecutors to increase the cases that are prosecuted in this regard, so that throughout our community, we're giving the same message that consent means words or overt actions by a person indicating a freely given present agreement to perform a particular sexual act with the actor. Nothing less. They have to consent affirmatively. And so I want to thank everyone for their help in getting this bill forward. I'm going to assist the sponsor and of course trying to get this to the floor as soon as possible. And now we'll hear closing remarks from the sponsor, the primary sponsor, Senator Torres.
Sidus Masi. Again, I just want to thank everybody for your continued support and for this very valuable testimony today and your show of support. It's truly appreciated. We know that alcohol facilitated sexual assault is a problem with the growing number of cases that we have. What I'm most pleased about with this bill is that it does in fact close the intoxication loophole that many of us have talked about today by expanding the law to include any person under the influence of a substance that renders them incapable of consenting. But I think what we also maintain is the known standard in our law, meaning that prosecution must prove that the defendant knew or had reason to know of the complainant's incapacitated state to be held culpable. So the idea that we can open up a floodgate, for false accusations the other way around, I don't think this bill accomplishes that at all. And it also contemplates, I think the law in generally and prosecutorial process contemplate what happens if both of the accused are intoxicated. I mean, the person who is the defendant and the accuser are both intoxicated. And I believe, Attorney Tenorio, you very clearly talked about how the incapacitation is made in light of all the facts available, right? And that there's different ways that jurors in the courts deal with how they arrive at deciding what incapacitation level a person might have been at, depending on all sorts of factors. So I think in terms of what might happen, any consequences of this loophole being closed, I think that there are things within statute right now that keep it pretty tight. The one thing that's obvious is that the intoxication loophole that has caused so many women who were assaulted under the influence, willful influence, their voluntary influence of intoxication, that they now have some way to seek justice, for being victimized while they were intoxicated, even though they voluntarily, drank or took drugs. So I thank everyone for their support. And Madam Speaker, I truly appreciate your commitment to seeing this through and hopefully make it to the floor. It is the least that we can expect from the committee to do this as best as we can for the victims. So thank you very much for that commitment. Sidus Masi.
Sidus Masi, Senator Torres, and again, everyone who was here for testimony on Bill 243. We're going to move to our next agenda item, which is Bill number 244-36, and I'd like to invite the primary sponsor to please introduce the bill. Senator Torres, you're recognized.
Thank you, Madam Speaker. Bill number 244-36 LS is an act to add a new chapter 163 to Title 8 of the Guam Code Annotated relative to establishing a Bill of Rights for victims of sexual assault and to further citing this act as the Survivors Bill of Rights Act of 2022. Madam Speaker, Bill 244-36, if enacted, would adopt a standard Bill of Rights for sexual assault victims in Guam. While the General Victims' Rights Act of 2004 has resulted in significant advances for crime victims and survivors, victims of sexual violence more than other victims are more likely to be blamed for the crime, assumed to be fabricating the crime, or taken less seriously than their injuries warrant. As a result, victims are sometimes discouraged from proceeding with their complaints. This bill is one important way to communicate to them that they are not responsible for the commission of crimes against them. Bill 244 guarantees a few fundamental rights, such as the right to advocacy, the right to informative rate procedures and notification, and the retention of all rights regardless of whether assault is reported to law enforcement or not. Some of these are currently required in various portions of Guam law. Thus, an important component of Bill 244 is that it helps victims of sexual violence to easily locate their rights in one chapter. Madam Chair, I do want to note that I am contemplating an amendment to this bill, which would expand the period for evidence collection and preservation from 5 years to 20 years. This would ensure we are consistent with the current national effort that is being considered under the Survivors' Bill of Rights in the States Act, which is a federal bill that encourages states to adopt local protections that mirror those at the federal level. Should this federal measure pass, states and territories that provide a Bill of Rights would be eligible for additional federal funding. This funding would be equivalent to a percentage of the formula grant funding that they already receive under the Violence Against Women's Act STOP grant from the U.S. Department of Justice. And with that, I thank you, Madam Chair, for hearing this measure, as well as my co-sponsors and for those in attendance today. Thank you.
Thank you very much, Senator Torres. I want to acknowledge the presence of Senators Talina Nelson, Sabina Perez, Chris Duenas, Telo Taitagui, Joanne Brown, and James Moylan. Thank you, Senators, for being present at this morning's hearings. Okay, so for the record, the committee requested feedback on Bill 244 in addition to the general public notice, specifically from the Bureau of Women's Affairs, Guam Behavioral Health and Wellness Center, the Healing Hearts Crisis Center, the Office of the Attorney General, Guam Public Defender Service Corporation, UOG Violence Against Women Prevention Program, UOG ISA Psychological Services Center, Catholic Social Services, Ali Shelter, UOG Social Work Student Alliance Victims Advocates Reaching Out, and Famalawan Rights. We'll now hear testimony on the bill. If I could just say the fiscal impact note on this bill and all the bills this morning stated that the proposed legislation is administrative in nature and does not pose any fiscal impact to the government of Guam funds. All right, we'll now proceed with testimony from the Bureau of Women's Affairs. Ms. Flores.
Thank you, Speaker Terlaje and committee members. And thank you for the opportunity again to testify on a very important bill, Bill 244-36, relative to establishing a Bill of Rights for victims of sexual assault and to further citing this act as the Survivors' Bill of Rights Act of 2022. The Guam Police Department's Domestic Assault Response Team, or DART, reported filing 190 cases of criminal sexual conduct in 2020. Nearly 90% of those CSC victims were female. Nearly 75% of the victims were under the age of 18. And those are just the cases that were reported. We know that sexual assault is the most underreported crime. And I just received GPD's 2021 CSC statistics, and the number of reported criminal sexual conduct cases has gone down in 2021 compared to 2020 from 190 to 158. And the percentage of sexual assault cases against victims aged 0 to 17 was at 109, which is a drop from 75% to 69%. But still, the fact that our underage victims are the majority of the victims is something that we really, really need to consider here, especially with Bill of Victims' Rights. And I also wanted to point out that the reduction in the number of cases, while it is generally good news, may not be such good news because we know that a lot of victims do not report. And so there is that to consider. We all know that rape, the most serious form of criminal sexual conduct, is one of the most underreported crimes. This is due in part to the shame and embarrassment felt by the victim, even though society is finally beginning to put the blame for this heinous crime where it belongs, on the perpetrator. And Bill 244-36 is in furtherance of this social awakening to the fact that no matter the circumstances surrounding this crime, it is not the victim's fault if he or she is raped. It is the fault of the rapist. The Bureau of Women's Affairs considers this legislation an important component in fighting the phenomenon known as victim blaming, and that we often see or hear about associated with sexual assault, and is in full support of all of the components of this bill. We do have one suggestion for this legislation, however. Subsection 161.3F calls for the retention of forensic medical evidence for a period of at least 5 years. And I'm not an attorney, so I would like to see if the attorneys that are present can comment on this. But with the advancement of technology regarding the collection of DNA evidence in cases of sexual assault, and with the ability of law enforcement agencies to now access familial DNA-based databases in order to solve decades-old crimes, and with the opening of the new state-of-the-art GPD crime lab on the GCC campus, we think it may be prudent to store forensic medical evidence until such time as the case is resolved. I personally know of a case where a murder involving the sexual assault of the victim went unsolved for nearly 50 years. But because of the DNA technological advancements mentioned above, an arrest was made and the case was finally solved 49 years later, providing closure for the victim's family. So I would recommend that. I would also like to just note that the agencies mentioned, Public Defender Service Corporation, Barrow, the coalition, because as Senator Torres mentioned, and Senator, thank you once again for sponsoring this important piece of legislation, that this could bring more money to our STOP grant. They are precluded from testifying because they're not allowed by federal statute to lobby in favor of legislation that benefits their agencies. So that's why you don't hear any of them here today. And it's why I'm here, because my salary is locally funded. So I can testify in favor of such legislation, but if they're federally funded, they're precluded from testifying because of the statute that says they cannot lobby for any legislation that would benefit their agency or organization. So I just wanted to make that clear. But of course, this is something that they would support because it helps the victims. And once again, it helps our society to look at these crimes as something that the perpetrator does and not something that the victim caused. And I think that's a really important component too. So thank you for the opportunity to offer this testimony in full support of Bill 244-36. We appreciate very much the efforts of the Guam Legislature to support and assist victims of sexual assault on our island. Thank you.
Thank you very much, Ms. Flores. We'll now hear from Attorney Christine Tunoria.
Thank you, Madam Speaker and senators of the Guam Legislature, including those who have sponsored this bill. Again, my name is Christine Tenorio. I'm an attorney. I was an assistant attorney general at the prosecution division for 9 years, also former head of the sex crimes unit and family violence prosecutor as well. I would like to thank the sponsors of this bill because this is necessary for the victims in our community, specifically the sexual assault victims. While the victims bill, the current Victims Bill of Rights has been helpful in apprising victims of what their what they can obtain from the criminal justice system, there is actually a gap specifically for sexual assault victims. And we know that because I've worked with hundreds and hundreds of victims throughout my tenure at the AG's office. And so many of them I would have to ask, Did they tell you about Healing Hearts? Did they tell you you can go there? Did someone tell you this? And so we kind of created our own like ad hoc Bill of Rights, going through what the victims need to be told as far as by other agencies, not our own. And so this shores up those loopholes. I do want to say that for I'm especially pleased with the inclusion of the subsections B and A, B, and C. And that's because what I think many don't realize is, apart from the actual sexual assault itself, the way the community reacts to the victims is equally traumatizing to those survivors. And what I mean is by this, anytime that we are in a jury trial, which we're all, there are many, many jury trials for criminal sexual conduct cases because of the nature of the case and the sentences that they can be imposed. It's the media attention that really traumatizes the victim, in the sense where if there are articles written about how maybe they were to blame, maybe she, the victim's not completely blameless for her or his alcohol intoxication, those are equally traumatizing to the victim in addition to the sex act. So I think that if we, the survivors, have this tangible Bill of Rights where they know that they are heard and they are being told that they have dignity regardless of what the publicity what the public has said or through the media has said, I think that this is very, it'll be a good thing for them. And they would feel like they would have the support they need from their legislators. I do want to bring attention to subsection F as well. I agree with Ms. Flores that the evidence collection should be retained until the case is solved. I'm actually not currently aware of whether GPD even gets rid of the DNA. For as long as I've been at the office, we've always been able to access the rape kits whenever we needed it. And so I don't know, because I'm not GPD legal counsel, of how they treat things, but I think that is a good idea, especially for the cold case files, as Ms. Flores had mentioned. The other thing though, and this is really a technical term, so where it says whether or not there are matches to DNA profiles in state or federal databases, the FBI has shied away from saying matches. They will not say that a DNA profile matches anymore. They have to use the phrase is consistent with the profile. So that's just something to be noted. I don't think that it is really too, I don't think it's really an issue here, because the intent of the language is there, and it's not hard to glean, but just a technical note about the use of the term match. And then the one subsection though that I did have a concern with is subsection G, to choose whether to participate in any investigation of the assault. So I understand, and of course it is a victim's right to engage in the investigation or prosecution of his or her case, but there are situations, this doesn't account for subpoenas. So you don't have a choice for subpoenas. And what that means is if the court orders your appearance in court for deposition, a grand jury proceeding, or the trial, you actually can't decline. So I understand what this subsection is trying to accomplish, is just getting everybody, you have your own right to figure out whether or not you want to proceed with your case. But there are some cases that are so terrible that it becomes the like law enforcement agencies' choice to proceed. And what I mean is by this, there are so many minor victims where the non-offending parent doesn't want them to proceed with the prosecution because the offending, they still love the offending parent. And in those situations, we don't really give them a choice of whether or not to go on with the investigation, because it's in the best interest of the community for this child to be protected, whether or not the non-offending parent is consenting or not. So I just wouldn't want any non-offending parent who is still supportive of the offending parent to shield their child from any investigation or prosecution of the case under this victim bill of rights. So that is the only thing that I would had a concern with, but I think this is a very good piece of legislation, and we really need to support the victims and protect their dignity. Thank you.
Thank you very much, Attorney Tunoria. Those are very helpful recommendations. We'll now hear from Deputy Attorney General Fred Nishihira.
Thank you, Madam Speaker and members of the committee. Thank you for this opportunity and to present testimony on Bill 244-36. We are still reviewing the bill, but wanted to let the committee know that we support the general intent of this bill. We also wanted to share that this may be an opportunity to make it easier for victims of sexual assault to seek protective order from the court. And we want to start by stating that we recognize and fully support all of the rights set out under section 163-30 of this bill. All victims have the right to be treated with dignity and respect throughout the criminal justice process. Victims also have the right to participate in the investigation and cases in their matter, as well as the right to be informed about the services and support that may be available. We applaud the government of Guam agencies, as well as the nonprofit groups who provide critical services, while we also ensuring that these rights are observed. We also appreciate the bill's intent of having our office publish and post the notice of these rights in various places. Our victim services centers provide services to victims of sexual assaults in a variety of ways, such as informing them of court hearings, other major developments in their case, referring them to other services, accompanying them to court, providing transportation, and answering questions about the court process. But that being said, there are certain services identified in this bill that our office does not provide, such as DNA testing and the filling of protective orders, or the filing, I'm sorry. On that note, we have heard from service providers that under current laws, victims of sexual assault are not eligible to use the protective order process set forth in 7 GCA Chapter 40. We have heard some services that it is from some service providers that it is easier for victim of family violence to get a stay away order from their perpetrator than it is for a victim of sexual assault. One thing the legislature to consider is authorizing protective orders for victims of sexual assault, abuse, stalking, or trafficking. As our office has prepared the rollout of a lethality assessment program with the Guam Police Department and the various victim service providers, we have surveyed similar procedure in other jurisdictions. These processes would allow for a streamlined petition process and expedited hearing similar to what is currently available to victims of family violence under Guam law. So with that, Madam Speaker, I submit our testimony. I also like to point out that I oversee the Victim Services Center. And so the process that we're talking about, and it'll be part of our upcoming budget bill, the lethality assessment program is one that we worked with the coalition. Certainly Jane and the Bureau of Women's Affairs is a program that's going to be rolled out from the Guam Department, Police Department. And it's basically a form that goes through very quickly with police officers and a potential victim. And I only want to tie this in, Senator Torres, with your other bill, I think it was 242. One of the questions that is asked in the form, or police officers would be asking, is whether or not it's a he, she, they have violently or consistently jealous, or do they control your daily activities, include your cell phones. So it all ties into this program too, that's being rolled out. I mean, that is being used in up to 34 jurisdictions. What would happen basically is a police officer, if they feel the victim is in some type of danger, they go through this process, they give the phone to the victim. The victim then would be put in touch with the victim advocate. And certainly if this bill passes, these are some of the things the victim advocate would let know. So we've worked with service providers, the DART program, Vero program, Coalition helped put together a conference where we did initial training. So we plan to roll this out later in the the month, we will be gathering information that can hopefully provide updated statistics and information to Jane and her group for perhaps additional funding as well for this program. Thank you, Madam Speaker.
Thank you very much, Deputy Attorney General Nishihira. I'd like to ask that regardless of the rollout, if there is a requirement to change the statute to allow protective orders for victims of sexual assault, that you please send that to us immediately. We should address that and not wait. Thank you. We'll now hear from Brianna Duenas, Social Work Student Alliance. Ms. Duenas.
Day, Honorable Senators. My name is Brianna Duenas, and I am the president of the Social Work Student Alliance at the University of Guam. We are in full support of Bill number 244-36 to add a new chapter 163 to Title 8 of the Guam Code Annotated, relative to establishing a Bill of Rights for victims of sexual assault, and to further citing this as the Survivors' Bill of Rights Act of 2022, introduced by Senator Mary Camacho Torres. According to the Guam Coalition Against Sexual Assault and Family Violence, in 2020, our island saw an upwards increase of almost 74 sexual assault cases, totaling 190 reported cases, compared to 116 reported cases in 2019. As we acknowledge the stigma surrounding sexual assault, we cannot ignore local data. Guam per capita has the second highest number of sexual assault cases within the US. The University of Guam Violence Against Women's Prevention Program reported that there are 64.2 reported cases per 100,000 people, compared to the national rate of 25.2 reported rapes per 100,000 people. The intent of the bill is victim-centric and ensures that these individuals, even in the midst of their vulnerability, have the fundamental right to advocacy. If passed, Bill number 244-36 will encourage and support reporting, along with providing protection and rights like any other crime victim within the criminal justice system. This bill recognizes the human dignity and worth of the individual by affording the victim the opportunity to access necessary resources to prevent further issues to the victim's mental and physical well-being. It is our hope that all members of this body chooses to address the injustice and gaps in our service by supporting Bill number 244-36. It's time we restore our justice system and recognize victims as people first. Thank you.
Thank you very much, Ms. Duenas. Very much appreciate the testimony of the Social Work Student Alliance and the University of Guam's efforts in this regard to assist victims. We'll now hear from Alexine Tiro, Social Work Student Alliance. Ms. Tiro.
Buenas and Hafaday, Speaker Terlaje, and all honorable senators. My name is Alexine May Tiro. I am an undergraduate social work student at the University of Guam. I am testifying on behalf of the Social Work Student Alliance at UOG in favor of Bill number 244-36 in support of the establishment of the Survivors' Bill of Rights Act of 2022, introduced by Senator Mary Camacho Torres. To begin, I would like to extend our sincere gratitude for the opportunity to provide testimony on behalf of our organization. As stated in the bill, victims of sexual violence more than other crimes are likely to be blamed for the crime, assumed to be fabricating a crime, or taken less seriously than their injuries warrant. These victims are sometimes discouraged from proceeding with their complaints and as a result are not afforded the protections and rights that other crime victims, receive in the criminal justice system. As some of you may already know, Guam has the second highest number of sexual assaults in the United States per capita. As a citizen of our island, this information is alarming. We are strongly in favor of Bill number 244, as most victims of sexual assault are not able to get the services they need, and it has been published that about 63% of these cases go unreported to the police. Despite underreporting, we continue to feel the impact and burden of sexual assault in our communities. The National Crime Victimization Survey recorded that the rate of rape or sexual assault more than doubled from 1.4 victimizations per 1,000 persons aged 12 or older in 2017 to 2.7 in 2018. The establishment of the proposed legislative bill will publicly support victims to seek justice and will guarantee them the rights to obtain the services and medical attention they urgently need. The bill will encourage victims to proceed with their complaints and will be provided the protection and rights that other crime victims receive in a criminal justice system, whether the crime has been reported or not. These victims are male individuals and female individuals, and so many of them are minors. Both female and male youth are exposed to early sexual victimization. The 2015 National Intimate Partner in Sexual Violence Survey found that 11 million, or 43.2% of females, reported that their first completed or attempted rape occurred prior to age 18. For men, 51.3%, or 1.5 million men, first experienced completed or attempted rape prior to age 18. Locally, the Guam Daily Post reported that the percentage of minors sexually assaulted in Guam has risen alarmingly from 69% of reported cases in 2018 to 71% in 2019 and to 75% in 2020. We must continue to address and prevent sexual assault in our community and publicly support victims of sexual violence. Bill number 244 may be an enormous help to someone in need. It sends a strong message and reinforces a culture of full support for sexual assault victims. It is possible to help change the future of our island and protect those who are vulnerable. I urge all members of Legislature on Guam to support Bill number 244-36 as a means to protect our people, especially those who are victims of sexual assault. Sincerely, Alexine.
Sitos Masi Alexine and the UOG Social Work Student Alliance, and especially for the statistics provided in your testimony. They're very compelling, and Sitos Masi. We'll now hear from the Guam Youth Congress Speaker, Stephanie Lorenzo. Speaker Lorenzo.
Hi, Sizos Masi, Speaker Terlaje. My name is Stephanie Lorenzo, and I'm here on behalf of the 33rd Guam Youth Congress to provide testimony in full support of Bill number 244-36 LS. Now, this bill aims to ensure that support systems and resources are in place for individuals who have experienced the tremendous trauma of sexual assault. This gives the victims a voice and power on how they would like to move forward following their assault. And the provisions outlined in this bill not only gives the victim the right to participate in the investigation, the right for their allegation to be taken seriously, but it also gives notice of when their test kits will be tested, which is especially important as many survivors can go months without knowing the status of their case. While these are only a few provisions, it goes to show how, if implemented, this bill will allow for a standardized practice of care for all victims. Now, this bill aims to further a victim's knowledge about the course of action they can take through ensuring that the victim is aware of what they have available to them, the resources in the community, and anything that can help aid them in the road to recovery. In closing, this measure will also allow local law to stand behind survivors of sexual assault by giving them a new set of rights to use in court. Thank you, Madam Speaker, for the opportunity. And I just wanted to note that the Youth Congress did reach out to the sponsor's office for her consideration to add the Guam Department of Education, the Guam Community College, and the University of Guam to be included in the Notice of Rights. That's section 136.40, page 4. So we do know that there is and the language in the bill already indicates any other appropriate place, but the Youth Congress did ask that Senator Camacho Torres does consider adding JDOE and higher institutions, seeing as nurses are mandated reporters, and this will allow and educate our youth to be to know their rights if they have ever experienced sexual assault. Thank you for the opportunity, Sizos Masi.
Sizos Masi, excellent suggestion. All right, I think that's all who signed up to testify. So we'll now proceed with questions or comments on the bill, beginning with the sponsor, Senator Torres.
Thank you, Madam Speaker. Thank you again, Christine and Jane and Fred, Brianna, Alexine, and Stephanie for your testimony. I'm so grateful that you fully appreciate the importance of this Bill of Rights for sexual victims. And I just want to mention that I have taken note of your suggestions to subsections F and G, and also, Stephanie, to the noticing and the different parties that would be part of that noticing. The only thing that I just will caution everybody is, as we go forward, I want to be sure that whatever we do with the final product of this bill, aligns with the federal act that is also, going through in the mainland, because we want to make sure that that where there's a survivor's Bill of Rights in the States Act, that the provisions and us having a Bill of Rights locally matches up so that we're not, we don't jeopardize our ability to receive additional federal funding towards our Violence Against Women's Act Stop Grant program. Because after all, the amount of resources that we can direct towards these victims and helping them to not only recover, but to also become whole and heal and seek justice, is dependent in great part to funding. So we want to make sure that whatever we do here aligns so that we can maximize the aid that can be made available to Guam. So thank you, everybody, and thank you very much to my co-sponsors and to you, Madam Speaker, for your advocacy and partnership as my second co-sponsor in this bill. Thank you.
Senator Torres. I'd like to ask the AG's office and the Attorney Tunoria, in regards to the discussion we had regarding media and how victims are possibly treated in the media. So I see on page 3, subsection C, that it says, and they have the right to be free from any suggestion that victims should refrain from reporting crimes in order to avoid unwanted personal publicity. Then on subsection J, it talks about to be apprised of the availability and process by which to seek protections through a temporary or final protective order if the victim believes that the victim is at risk for re-victimization or further harm by the perpetrator. And I was wondering if we could expand this. You think they could be entitled to protection through a protective order, not just against the perpetrator, but against any other person, or I don't know how much we can protect them from publicity, but have you seen that in any other states, any other efforts like that?
Thank you, Madam Speaker. I'm not aware of any other states that account for the protection against third parties. I do want to say, though, that that exact issue has come up with many of my victims because of the treatment they get at the court by family members of the perpetrator who are present watching the trial. So I do think that is you recognize that's an issue. So I don't know if subsection J, I think it can be included there, accounted for there, if we're talking about third parties. I'm not sure about the media, though. I think that's why one of the earlier bills that was introduced this year, it was supposed to account for a sexual assault victim's right to privacy. That was supposed to be the bill accounting for the publicity and the really unfair media attention, just because sometimes media doesn't report both sides equally. So I'm not sure if that answers your question. I did want to add, though, what I actually forgot to say earlier was that I noticed that this bill doesn't have the responsibility portion, and I think this goes to the media question. The original Victims' Bill of Rights of 2012 has a section on responsibility for rights and services, which says, if basically everyone, there will be no legal action for anybody who violates the Bill of Rights, but you're subject to reviewing authority. That provision is not provided for in this Sexual Survivors Bill of Rights. So I think that it might be helpful just so that the courts or agencies don't say, well, I'm not liable for anything, or I don't have a responsibility to do this because it's not delineated in the bill.
All right, appreciate that. Thank you. I know, Ms. Flores, you had your hand up, but Attorney Nishihira, is there anything you'd like to add to that?
As suggested earlier, Speaker, we will submit additional language, but because I represent the Victim Service Center, and from a victim point of view, but obviously it may have impact on the prosecution side of the house too, just like Christine has said. I do have to have some balance that make sure what we suggest doesn't have an impact on prosecutor's case. So we'll submit additional language.
All right, I would
Recommended
appreciate
language.
that. Thank you. Ms. Flores? The mute, sorry, Ms. Flores, we can't hear you.
Think you would get used to this unmuting. But I just wanted to address the media portion as a former member of the media. And I know that Christine and I have talked about this a lot. And I did write a column in the Pacific Island Times earlier this year about how the media re-victimizes victims, and that they should be aware of this and not go into so many details. And I noticed that there was an article in the Post yesterday, and they were very careful not to, when it was a school reported the assault, and they didn't name the school, and they didn't say that the victim was known to the person, because all of those are identifying factors. So I think that I'm not aware that you could legislate any kind of media activity or the way they handle it. But what we can do is we can just make them aware. We can just make them aware that, your job is not to re-victimize the victim. Your job is to make people aware of something, but not in a way that re-victimizes the victim. And if those of us who are on the periphery and can have some influence with the media can remind them that, when you give out too many details of a crime that identifies the victim, you're not helpful. You're not helping the situation at all. So I just wanted to say that I don't think it can be handled legislatively, but I think there are other ways to make the media aware that you need to handle these types of cases, very gently and I think they are, for the most part, listening now.
All right, thank you very much. I'll now open it up for other senators. Senator Nelson, you're recognized.
Thank you, Madam Speaker. Attorney Nishihira, I do have a question. You mentioned earlier in your testimony on the on another GCA for the authorization of protective orders for victims of sexual assault. Can you recite that GCA that you mentioned?
So maybe Christine, because she was a practicing prosecutor, she can explain the differences process-wise from a protective order versus which a family violence case can obtain, whereas a sexual assault type case has to go through a civil process called a temporary restraining order. And so process-wise, maybe Christine, you can help me out. Like I said, she was actively involved in that practice, that area. I have not had the number of years, certainly, that she has.
Sure, thanks, Fred. So for sexual assault, what we have encountered is that it's actually more difficult for a sexual assault victim to get a restraining order. We're not really sure why. I think it also has to do with the standards set out by this statute. But normally the courts are looking for physical injury, and sometimes people, you would think, right, that a sexual assault equates to physical injury, but that's not really how the courts interpret that. So I think that's what Mr. Nishihira was stating earlier, is that that process is different. In order to get protections from them civilly, they would have to go through the civil restraining order process. The criminal restraining order process is automatic, because what happens is the restraining order is the order of conditional release given by the magistrate when the defendant is first brought before the magistrate judge to answer to the charges. So you're given an order of conditional release, and it says stay away from the victim, and that's the criminal procedure for that. It's automatic, whereas a civil restraining order is not.
Okay, so do we need to make any adjustments in the GCA for that?
So I think the disconnect is this, for criminal, we can only account for the defendant. So I've had mothers of minor victims just crying to me saying, you know, Christine, the family keeps harassing me at court. And I was like, unfortunately, I can't do anything because I can only ask the judge to limit the defendant's contact with that person, but not you. So that's when they would actually have to go through the civil process. And I can tell you just from personal experience with these victims, I've had, again, parents of minor victims come back crying and they're like, the agency couldn't help me. And these are, you know, they couldn't afford a lawyer, so you have to go through the indigent services. And they're like, oh, they couldn't help me get this restraining order against the defendant's family who's clearly harassing me. And so they just went unprotected for the whole trial. So that's the difficulty. And I think that's what the subsection J is trying to accomplish. But I think that what Mr. Nishihira's point is that it's not easy if it's not codified somewhere where you have the authority to ask for a protective order for a third party.
We need to codify it. Okay, thank you. Thank you, Madam Speaker. I just wanted to ask that one question, and thank you, Attorney Nishihira and Tunoria and all of the social work students for coming out to speak today. I was not present for the introduction of these bills. I was on military orders, so I would like to be a co-sponsor for all the bills that we've heard today, if that would be okay. And then I fully support these bills, and I thank the author for the work that she has done to protecting the rights of victims of sexual violence. Thank you, Madam Speaker.
Thank you, Senator Nelson. Senator Perez, you're recognized.
Yes, thank you, Madam Speaker, and thank you to all that have come here today to provide testimony, and thank you to the sponsor as well for introducing this bill. Yeah, I'm just listening to all the comments, and I appreciate the vetting and suggestions from the people that have come here today, and I am full support of those addressing those issues. And I do hope that, you know, whatever changes we make to strengthen this bill, that it is in line with the federal guidelines. And I think these are pretty reasonable things to amend. These amendments are pretty reasonable. So I continue to listen, and I look forward to strengthening this bill. Sidus Masi.
Sidus Masi, Senator Perez. Senator Duen, you're recognized.
Madam Speaker, and once again, thank you to the author for this great piece of legislation and allowing me to be a co-sponsor. It's like, once again, this esteemed panel has put forward some recommendations, and I'm sure the author will incorporate, and we'll work on that in a markup and make sure the bill is prepared for the floor with those suggestions in mind. And those are really all my comments. It's been some great work done this morning. So just want to see, Madam Speaker.
Masi, Senator Duenas. Senator Taitigui, you are recognized.
Thank you, Madam Speaker, and to all that who's here to testify. I'm looking forward to, Fred, your testimony after reviewing it thoroughly on the bill. There are some concerns I have too with certain sections of the legislation, particularly in 163.30C as well as F. You know, some concerns there. So I'm looking forward to your thorough review of it. I also have a question maybe to I was saying Senator Tenorio. Christine, that's a, and well, if you do plan on running, please make it Republican anyways. Anyway, you know, we know that there is a Crime Victims' Rights Act 2014. So wouldn't it be more appropriate that these provisions within Bill 244 become an article or amend the provisions contained in the Crime Victims' Rights Act of 2004? Wouldn't it be beneficial that similar laws are kept contiguous within a chapter?
So I had looked at the placement earlier, and thank you, Senator Taitigui. I looked at the placement earlier, and I think that this was a good placement for it, because I think because the legislative intent for this particular Bill of Rights doesn't necessarily extend with the original regular Bill of Rights, because these are very specific to sexual assault survivors. I think that the fact that this goes right after the Victim Bill of Rights, it's just very clear as to what the rights contained here are only going to be applicable to sexual assault victims, because the subsections here don't really apply to any other crime, except for maybe subsection C and subsection I and J. Maybe those apply. So to the extent that the legislators wanted to include that in the Victims' Bill of Rights of 2012, I think, I mean, that would be a way to do it.
So that it's contiguous, it stays in the same area. That was my concern. Have you had a chance to look at the New York State Sexual Assault Victims Bill of Rights as well? Well, I'm sure you did a lot of your research on this, preparing for this legislation. But have you had a chance to look at that? New York State Sexual Assault Victims Bill of Rights. It's very condensed. It's very thorough.
I personally have not seen the New York Bill of Rights.
Okay. Thank you so much, Christine, for all your hard work on this legislation, on all legislations that were brought here today. And I look forward again, Fred, for your testimony, written testimony, and that, like I said, in those particular areas. And if you can take the opportunity to review the New York State Sexual Assault Victims Bill of Rights Act as well, may be helpful in making any kind of recommendations to make this bill stronger. I appreciate your time as well. Thank you, Madam Speaker.
Thank you, Senator Taitukui. Senator Brown, you're recognized.
Thank you very much, Madam Speaker. I know it's been a long hearing. I don't have too many more comments, but I certainly look forward to whatever amendments can be brought forth to strengthen the bill, and certainly supportive of the legislation. And I'm hopeful that we can send a message out and a standard out in the community that, you know, there's consequences to this type of behavior. Even though I mentioned earlier, I don't know if that stops, you know, bad people from doing the bad things that they do, but I think we need to voice that out in our community. These actions are not acceptable. And that if someone chooses to go down this road, that there's going to be consequences. We have too many victims, too many innocent victims in our community that have suffered as a result of especially sexual assault and sexual abuse. And, you know, I just think that message needs to be strengthened out there, that this is not okay, and we're not going to put up with it. So thank you to the sponsor and certainly everyone else that's taken the time to provide testimony this morning. With that, Madam Speaker, thank you for the opportunity to comment.
Thank you, Senator Brown. Senator Moylan, you're recognized.
Thank you, Madam Speaker, and again, the panel. Very helpful information. UOG students, Youth Congress, and Attorney General's office. Again, Attorney Tunoria, thank you very much for your explanation. Thank you, Madam Speaker.
Thank you, Senator Moylan. And again, thank you to my colleagues for being present during this hearing. I think it's very important we hear directly from those testifying. And I'd like to now open the floor for the sponsor to close on the bill.
Thank you, Madam Speaker. I just want to close by going back to what the intent of this whole bill is. Basically, we are aware that the Crime Victims' Rights Act of 2004 resulted in significant advances in the recognition and protection of the rights of crime victims and survivors once they enter the criminal justice system. But we also know that victims of sexual violence, more than any other victims, are likely to be blamed for the crime, fabricating the crime, or taken less seriously than their injuries warrant. These victims are sometimes discouraged from proceeding with their complaints, and as a result, are not afforded the protections and rights that other crime victims receive in the criminal justice system. And it is for this fundamental reason and intent that we have to accord victims of sexual violence the rights which may be easily located in one chapter, as we aspire to have this Survivors' Bill of Rights Act of 2022. So thank you, everyone, for your wonderful testimony, and thank you again, Speaker, for your advocacy in seeing these bills through. Situs Maasi, everybody.
Situs Maasi again to those testifying, especially, and we will incorporate all your recommendations, and anything you want to submit in writing, please do so. There being no additional individuals to present for the testimony, this committee will consider bills 243-36LS and 244-36LS duly heard. This public hearing is now adjourned. It's 11:54 a.m. Be safe.